afternoon, everyone. Thank you for joining us today for today's online talk, which will be starting shortly. Before we begin, and while we're waiting for the room to fill up, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
All right, thank you, everybody. Welcome again. Thank you for joining us again for today's talk, which is entitled Resolving Disputes in Administration of Estates. My name is Eric, and I will be your moderator for today's session. Before we begin, I would like to introduce the firm and what we do. Mao & Kuai & Associates is a mid-sized firm that was founded in 1985 by our Dato' Mao & Kuai. Our able team today comprises of 22 lawyers and a support team of 19. Dato' Mao is today a consultant with the firm following his retirement from Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small and medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, a dedicated employment industrial relations team, as well as a department focused on servicing the needs of individuals and families. Our practice groups, as you can see from the slide, indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which are broadcasted online and live. But with the COVID-19 pandemic, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our 18th talk this year, and which have been attended by some 3,000 attendees. Today, we are expecting around 100 people who have registered. Please visit our website at maoandkuai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice for your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, I would like to introduce our speakers today. We have two speakers, Ms. Prisilla Chong and Ms. Fung Carmen. Prisilla will be speaking today, first, followed by Carmen. Prisilla is a senior associate in our dispute resolution department, graduating with a Bachelor of Laws from Cardiff University. She was admitted to the Malaysian Bar in 2017, and she practices in the real estate, commercial, corporate and administration of estates related disputes. We also have Carmen. Carmen is our associate in the Dispute Resolution and Individuals and Families Department. She graduated from Cardiff University with a Bachelor of Laws. She was called to the English Bar in November 2018, admitted to the Malaysian Bar in 2020. Carmen's areas are general litigation, debt recovery, probate, corporate and commercial litigation, joint management body matters, and family law matters. Our speakers will target to complete their presentation by 3:45, and they will address the questions posted in the Q&A chat. So please do post your questions at the Q&A chat box, upvote or like the questions you think you want answered, or if the questions are similar to your question. And the most popular questions will be discussed and answered by the speakers during the Q&A session. So please remember to put your questions at the Q&A box down below. Okay, with that, I will pass the floor to Prisilla, who will bring us through the talk points and begin her presentation. Over to you, Prisilla.
Thanks, Eric. All right. A very good afternoon to all our participants here today. Thank you for taking the time to attend our NWKA online talk series. I'm Prisilla. Today, I'll be sharing my insights on administration of estates with you. My talk points for the day is, firstly, applying for grant of representation, and secondly, duties of executors and administrators. Following that, my colleague Carmen will be discussing the topics on common problems and mistakes in administering estates and going to court to resolve disputes. On my first talk point for applying for grant of representation, I will first begin with introducing the applicable laws in Malaysia, which governs the will writing and also administration of estates. If the testator or deceased was residing in West Malaysia, the applicable legislations will be the Wills Act 1959, Distribution Act 1958, and Probate and Administration Act 1959. If the testator or deceased was residing in East Malaysia, the legislation on the right-hand side of this table here will be applicable. I'll now move on to discuss the different types of grant of representations. There are in general two types of grant of representations. In order to determine which grant of representation should be applied for, the beneficiaries of the estate will first need to determine whether the deceased passed away with or without a will. On the left-hand side here of this flowchart, you can see that we have set out the process for situations where persons pass away with a valid will. And on the right-hand side here, you will see the process or procedure for intestate situations. If the deceased passed away with a valid will, the person applying for grant of representation will be the executor named in the will. The grant of representation here is known as the grant of probate. The executor will have to administer the estate based on the terms provided in the will after obtaining the grant of probate. In contrast, if a person passed away without a will, persons who are interested in the estate may apply for the grant of letters of administration. The High Court will have the discretion to grant the administration to whom it thinks fit. The person so appointed will be known as an administrator. Since the administrator is not appointed pursuant to the terms of the will, the High Court will require the administrator to provide an administration bond as a security to protect the interests of the beneficiary of the estate. In addition, the administrator will also need to apply for a distribution order in the event that he or she wishes to sell the property. Moving on, you may be wondering what are the differences between a grant of probate and a grant of letters of administration. First of all, the main difference between a grant of probate and a grant of letters of administration is the manner of distribution of assets to the beneficiaries. If there is a will in place, the distribution will follow the terms of the will. If there isn't a will, it will follow the statutory manner of distribution under the Distribution Act 1958. In general, the time frame to distribute the assets will be slightly longer in comparison to a grant of probate because there is the need for a longer time frame to apply for the grant of representation. As mentioned in my earlier flow chart, you can see that there are more steps involved in applying for a grant of letters of administration. Namely, the administrator will first need to apply for an administration bond and also a distribution order before proceeding to the distribution of assets. In addition, an administrator cannot sell or transfer an immovable property without a High Court order. Moving on, if you are an executor appointed under the will and you are now considering to make an application for grant of probate at the High Court, the necessary documents that you'll need will include the original will of the testator, death certificate, the NRIC of yourself and also the beneficiaries, and the details of the properties. On the other hand, if you're applying for a grant of letters of administration, you will first need to determine whether you have interest in the estate. The persons who generally have an interest in a deceased estate will include spouse, children, parents, siblings, grandparents, uncle and aunts, great-grandparents, and so on. The High Court has a duty to consider the rights of all persons interested in the estate of the deceased. The necessary documents that an applicant will need to produce is similar to an application for grant of probate, but you will need to provide evidence such as a birth certificate or a marriage certificate to prove that you indeed have an interest in the estate. In my slide here, you can see the manner of distribution under Section 6 of the Distribution Act 1958. This distribution under the statutory provision will depend on whether there is a surviving spouse or parents or children under the estate. In the event that there is only a surviving spouse, he or she will be entitled to the whole estate. And in the event that there's spouse and parents surviving the deceased, it will be half share each. And in the event that there is a spouse and the deceased is not survived by the parents and there are children, usually the children will have more share in the estate because they will need the assets for their future living expenses as they are still young. I will now move on to my second top point on general duties of executors and administrators. The three subtopics that I'll discuss today is firstly on eligibility, secondly on duties, and thirdly remuneration. On the point of eligibility, you need to be at least 18 years old and above to be an executor or administrator. There must be a minimum of one person to act as an administrator or executor. If there is a beneficiary under the will or an intestacy, the minimum number of executor or administrator will be 2 persons unless the court is satisfied that the administrator and executor can act alone in administering the estate. Alternatively, if there is beneficiary under the will or intestacy, you may also appoint a trust corporation to act as an executor or administrator. The general rule is there can only be a maximum of 4 persons acting jointly as an executor or administrator. If one of the executor passes away, the representation of the estate will pass to surviving executors. However, on the other hand, if the administrator has passed away without fully administering the estate, subsequent interested applicants will have to apply to the High Court for a grant of letters of administration de bonis non. The general duties of executors and administrators will include, firstly, you have to look for a lawyer for legal advice on whether you should apply for a grant of probate or grant of letters of administration. And following that, you need to ascertain assets and liabilities of the deceased, inform the banks, credit card companies, government agencies of the deceased death, administer the estate by distributing the assets. Executors and administrators are fiduciary, and hence they owe a fiduciary duty to the beneficiaries, which holds a very high threshold. And lastly, they hold assets on trust for the beneficiaries. Just now, I mentioned that executors and administrators will have to administer the estate. How do we consider the administration is being done? Firstly, the administrator or executor will have to pay the estate's debts and liabilities. This will include funeral, testamentary, and administration expenses. Administration expenses can include the legal fee that you have incurred for applying for a grant of probate or grant of letters of administration at the High Court. The executor and administrator will also have to pay off secured and unsecured creditors of the deceased before distributing the assets to the beneficiaries in accordance to the Will or Distribution Act. If there are assets outside Malaysia, the executor administrator will have to apply to reseal the grant obtained here in the foreign country. Administrators and executors owe fiduciary duties to beneficiaries. They are required to act in good faith, diligently, promptly, impartially, and in accordance to the terms of the Will and Distribution Act at all material times. The paramount duty of the executor and administrators is to act in the best interest of the beneficiaries and estate. The duties of an executor or administrator is considered to be completed when the estate is fully administered, he or she has rendered proper accounts to the beneficiaries, and upon check and balance being done, they will need to obtain confirmation from all the beneficiaries that they have received their respective shares and assets in the estate. Now you must be wondering, this task as an executor administrator is so daunting and so difficult. Will you be able to obtain a remuneration for carrying out the duties? Section 43(1) of the Probate and Administration Act provides that the court may allow executors and administrators a commission not exceeding 5% of the value of assets collected after the assets has been administered by the executors and administrators. However, this is wholly up to the discretion of the High Court, and in the event that you intend to apply for this commission, you have to make a formal application supported with evidence of your conduct in administering the estate. I will now pass the floor to Carmen, who will be discussing the next top point on common problems, mistakes in administering estates. Thank you, everyone.
Thank you, Prisilla, for sharing with us on the first two top points on the grant of representation and also the duties of executors and administrators. I will now take over to address the topic on common problems and mistakes in administering estates and on going to court to resolve disputes. These are usually the common breaches or mistakes by the executor or administrator in administering the estate. So the common breaches are, firstly, breach of trust, where executors or administrators have been acting in their own self-interest, and they may also have been misappropriating money. Another example is conflict of interest. For an example, an executor is buying the estate's properties at a lower price for his or her own benefit. Thirdly is where the executors or administrators failed to distribute assets, or they have failed to provide the estate accounts to the beneficiaries. We will then move on to discuss the common problems faced by beneficiaries, particularly in challenging a will. Today, I will zoom in this topic to address it in detail. So these are basically the grounds to challenge the validity of a will: lack of testamentary capacity, suspicious circumstances, undue influence, or forgery or fraud. We will consider the grounds in turn. For lack of testamentary capacity, it would mean that the testator is not of sound mind, memory, and understanding at the time of the preparation of the will. So you will have to bear in mind that the person who alleged the validity of the will bears the burden of proving testamentary capacity. That means that if you are suspicious that the testator is not of sound mind when he or she executed the will, you will have to prove the same. The next question then goes to, how do you prove testamentary capacity? So we will look at the case of Hem Singh and Inda Kaur, and the case of Yu Bun Yap provides on how to prove testamentary capacity is where the content of the will was read and the testator understood the content, the effect, and the extent of the disposal of the property. So you can also take note when you're executing your own will to avoid such problems arising upon your demise. The case of Yu Bun Yap and Lee Ing Chin also provides that a medical report can be another document to prove the lack of testamentary capacity. You can show that the testator suffered unsoundness of mind or lacked the mental capacity to make a will. You need to possess the testator's medical report, or you can obtain it from the hospital to prove this. However, you should also take note that mere bodily ill health or imperfect memory is insufficient to prove testamentary capacity. So you will need to have a form of documentary evidence, as mentioned earlier, to prove these grounds in court. Next, the ground for challenging the will is if there are suspicious circumstances in the process of the execution of the will. The burden of proof falls on the person proving the will to dispel suspicious circumstances by showing that the will was read to the testator and the testator knew and approved the will. So next you'll be wondering, what are the examples of suspicious circumstances? One example would be that a substantial gift was bequeathed to a person who prepared or was closely involved in the preparation of the will. One method that we suggest to overcome this problem is that you can avoid suspicious circumstances to show that the testator obtained independent and neutral legal advice in preparing his will and are properly advised by his lawyers. We should also avoid making any suspicious circumstances in the process of preparing the will. For an example, beneficiaries cannot be a witness to the will or he cannot be the person who drafted the will. This is to avoid beneficiaries getting involved in the process of the preparation and execution of the will. You can also raise undue influence as a ground to challenge the will. The same thing happens where the person alleging undue influence will then bear the burden of proving it. The test to prove undue influence is set out in the case of Carmel, Mary, and Josephine, which the test states that the testator was coerced into executing the will in the form that it has taken, or the will was not the voluntary act of the testator. We will then move on to the grounds of forgery or fraud. This is when you suspect that the signature of the will is forged. So to allege this ground, the person who alleges it will also bear the burden of proving it. Suspicion on forgery or fraud usually happens when the testator's signature on the will does not bear the true and genuine signature of the deceased, and it's forgery. The allegation of forgery is most commonly raised in a situation where there are two wills in existence, typically where the wills executed are in or around the same period of time. It will then raise a suspicion that one of them might be forged. For cases as such, you can engage a handwriting expert to prove that the signature does not belong to the testator and tender such evidence to prove your suspicion. So where there are breaches or mistakes by the executors or administrators in administering the estates and problems faced in terms of the validity of the will, you will be wondering that what am I supposed to do? Maybe you're feeling lost in terms of what you're going to do next or what other recourse you have. So having identified some of the common problems and mistakes, we'll now look into how we can resolve those problems or disputes. As we all know, a settlement out of court is always the ideal situation because it saves time and cost as well. Therefore, before resulting in going to court, we highly encourage beneficiaries to have a discussion with the executor or administrator together with the stakeholders of the estate. During the discussion, you should request for an update on all the estate's affairs, such as request for the estate accounts, can ask the executors or administrators about the distribution of the asset, the status of it, the dividends accrued from shares, or rental income generated from properties. So if the dispute between you and executor persists, you can commence an administration action against him or her at the High Court. The purpose of administration action is to obtain directions on questions that arose during the administration of an estate. So this procedure is provided under Order 80 of the Rules of Court 2012. And the definition can be found under Order 80. It simply means that an action for the administration under the direction of the court of the estate of a deceased person or for the execution under the direction of the court of a trust. We'll move on to this flowchart. There are generally three categories of situations where you can commence administration action against an executor or administrator. The first category is where, in order to determine questions or issues that arose during the administration of the estate of a deceased person, or in the execution of a trust. Second situation is in the event you want the court to determine the composition of any class of persons having a claim against the estate of such a person or in any property subject to a trust. Thirdly, you can ask the High Court to determine the rights or interests of a person claiming to be a creditor of the estate of a deceased person or to be entitled under the will or on the intestacy of a deceased person to be beneficially entitled under the trust. Moving forward, other than administrative action, you can also consider the removal of the person as an executor or administrator if he or she has conducted severe misconduct in administering the estate. The court will also go by the primary consideration, which is to ensure that the interests of the beneficiaries and the estate to be protected. You can apply to the High Court for the revocation or removal of an executor or administrator. The court is empowered to remove an executor or administrator where there is a failure to act because of unfitness or incapacity to act. The relevant provision for a removal of executor is provided for under Section 34 of the Probate and Administration Act 1959, which reads, any probate or letter of administration may be revoked or amended for any sufficient cause. However, the phrase of sufficient cause is not defined in the Probate and Administration Act. The federal court case of V. Ku Bu Gong has shed some light on the objective test to remove an executor or administrator. This objective test will require the court to determine the welfare and interest of the beneficiaries of an estate as the paramount criterion when deciding whether there is sufficient cause to interfere with the estate affairs by revoking the grant of probate and grant of letters of administration. In the event that court decides that it is in the welfare and interest of the beneficiaries to remove the executor or administrator, then they will proceed to revoke the grant of letter of administration or grant of probate. There are a few situations where the High Court has revoked the grant of probate or grant of letters of administration. One of them is where there was serious misconduct committed by the executor or administrator. This perhaps will involve misappropriation of monies, failure to render accounts, or might have intermeddled with the assets. If the beneficiaries have no option, they can apply to remove them and apply to take over conduct of the estate. Next is when the relationship between the parties has deteriorated to the extent that executor or administrator can no longer effectively administer the estate. Examples will be that the executor or administrator acted hostile towards the beneficiaries. Third situation is where the grant of probate or grant of letters of administration was obtained by misrepresentation or fraud. However, in the case of Leong Seow King, it actually shows that court is generally slow in removing the person named in the will as executor. The court is actually trying to honor the wishes of the testator by appointing the executor. You can also consider lodging a caveat to ensure that no grant of representation is made. The procedure is provided under Order 71 of the Rules of Court, and it can be entered at the High Court Registry. Do take note that the caveat is actually valid for only 6 months. So when the caveat is lodged, you have to take prompt steps to resolve any disputes within 6 months, or alternatively, you can apply to renew the caveat after the expiry of 6 months. Citation is another option to consider, whereby you can cite or issue a notice to the executors in a will when they delay or decline to apply for grant of probate. However, you must also take note that a caveat must be entered before issuing a citation. So you must enter a caveat following that, which is the citation. The citation procedure is provided under Order 71, Rule 42 of the Rules of Court 2012. In Section 40 of the Probate and Administration Act, says that the High Court has the power to summon any person named as executor in any will to prove or renounce probate of the will and do any such other things concerning any will. Moving on to the reliefs. These are the reliefs you can seek from the High Court, and it will include an order to verify accounts, an order to require payments into court, an order to direct a person to do or abstain from doing a particular act in his capacity as an executor or administrator, an order approving any sale, purchase, compromise, or other transaction by a person in his capacity as an executor or administrator, or also an order directing any act to be done in the administration of estate. So these are the reliefs that you can seek when you're bringing an action to court for against the executor or administrator. So that's all from me today. I will now pass the time back to our moderator, Eric, for the Q&A session.
All right. Thank you very much, Carmen and Priscilla, for your detailed presentation. Well, it looks like our attendees would like you to share even more of your knowledge on this issue, as we have around 22 questions so far. So, well, if the attendees would like to ask even more questions, please remember to drop your questions at the Q&A box. We'll see how far we can get through all these questions. So I hope our speakers are ready. And I'll start with the first question, right, by Gerard. So, is it a legal requirement to apply for a grant of probate where a simple will exists? Can the estate be legally distributed according to the will by the executor without a formal grant of probate? Yes, can I have Carmen to answer this question?
Okay, thanks, Eric. Thanks, Gerard, for the question. So basically, a short answer to your question is no. It is actually a legal requirement to apply for a grant of probate, and with only the grant you can go and apply for transfer of the assets. You cannot just bring a duly executed will to any of the banks or land office to do the transfer. You will need to have a grant of probate to do so. Yeah.
Okay, thanks, Carmen. All right, second question by Kirsten. Is there any circumstance in intestacy that administration will be granted to ARB? What if they are minor beneficiaries? Prisilla?
Thanks, Eric. I'll take this one. There are two parts to this question. The first part is whether there are any circumstances in intestacy that administration will be granted to ARB. ARB stands for Amanah Raya Berhad. It's a public trustee corporation. There are circumstances where administration is granted. For example, if the court thinks that it's fit for them to act when the beneficiaries are unable to agree on a common appointment of an administrator. The second part of the question is, what if they are minor beneficiaries? In the event that they are minor beneficiaries, it is not necessary that ARB will come in. You can agree to appoint two administrators in place of a trust corporation. Thanks, Eric.
Okay, thank you. Next question by Mr. Anonymous. What is the difference between the will version offered by some financial institutions and will writing offered by lawyers? Carmen?
Okay, so generally, there are some differences, but I would think that it will be generally the job scope will be roughly the same. It's just that the will writing offered by lawyers will be more comprehensive, as in lawyers can advise as to the validity of the will and what are the possible challenges, and can advise better on what are the disputes in any event your will is not well drafted. And probably the difference will be the fee structure, which we are unsure of. What kind of fee structure that will be offered by financial institutions. That's from me.
Okay, yes, indeed. Please look for a lawyer if you want to draft a will. All right, next question. Will there be a problem of transfer if the beneficiary is a foreigner? Prisilla?
Sure, Eric. In the event that the transfer of an asset from the estate is to a foreigner, there is no issue for the foreigner to inherit the asset. However, if it's a property or if it's an immobile property, then it will be subjected to different land offices requirements, additional requirements to obtain state consent. Thanks, Eric.
Okay, all right. Good. Now, next, what does it mean by resealing grant? Carmen?
So a resealing of grant of probate usually applies to properties overseas. So the situation is where you have obtained a grant of probate in Malaysia, let's say, and the will also states that there are properties in overseas. So you can, after obtaining the grant of probate, you can bring the grant of probate to the other countries, foreign countries, to apply for a resealing of a grant of probate. Yeah, so there's no need to apply like two different process in two different countries. You just have to take a grant of probate to get it resealed at other countries. Yeah.
Just to add on that point, it'll be Commonwealth countries only.
Yeah, Commonwealth countries only. Thank you.
Okay, Commonwealth countries. Right, next question. How long does it take to extract the probate and LA for the KL or Shah Alam High Court? Prisilla?
Okay, Eric. For probate, it will generally take about 3 to 4 months. For LA, it might be slightly longer, probate is 2 to 3 months and LA is 3 to 4 months. It doesn't really matter which court because most of the situation now is online, so things move pretty quickly these days.
Okay. Thank you. All right. Okay, the next question is a bit lengthy, so I'll try. Would the supporting affidavit for an application for LA with will annex be more similar to one in an LA application or a probate application? The forms in Form 159 of the Rules of Court are unclear on this. If the beneficiaries of the will are different from the next of kin, if there were no will, do the next of kin need to affirm affidavits to confirm that they do not wish to claim under the estate or contest the will? Whew, I'm really tired after reading this question. Well, I think I'll leave it to the speakers. Any of you want to take this up?
I will try to break it down and answer, and maybe Priscilla can talk.
Yeah, I'll top up.
Yeah. So I'm guessing that the supporting affidavit for application for LA with will annex, it's more on the divorce non. So it will be more similar to an LA application because it is, yeah, so the process are the same. The cost papers filed will be the same as an application for letters of administration. Yeah. And maybe Priscilla, you would like to add on?
Yes, sure. I believe this is a question from our learned friend. So the first part of the question is, would the supporting affidavit for an application of LA with will annex be similar with the one in the LA application or probate application? So in the affidavit for an application for LA with will annex, it's very much similar, but you will need to annex the will as an exhibit to support the application. I think that's the only main difference between the affidavits. Second part of the question is, if the beneficiaries of the will are different from the next of kin, if there is no will, do the next of kin need to affirm affidavit to confirm that they do not wish to claim under the estate or contest the will? If there's a will in place, the testator's intentions are clear. Therefore, persons that are not stipulated in the will do not have any rights to contest the will unless there is suspicious circumstances or circumstances that have been mentioned by Carmen earlier. Eric, back to you.
Okay, thank you very much. All right, we have a next question from Mr. Ho again, and I've noticed that Mr. Ho has a few other questions. So I think to be fair to the other attendees, I will get the speaker to answer this question, the next question, but then after that I'll skip to the other attendees. All right. So okay, next question. Can the executor and administrator use the assets of the deceased to pay for litigation costs if sued by the beneficiaries? Carmen?
Okay, so basically, it will depend on the terms in the will, the clauses in the will. So you will go and check back whether you can recover, whether the terms in the will covers for all the costs arising from litigation. And it will also depend on the type of suit in court as well. Some might be the breach of the executors or administrators. Yeah. So
if the administrator or executor's conduct is in good faith, then very likely that they can claim back the costs incurred in the litigation.
Okay, thank you. Right, and the marathon continues. Next question. Can a beneficiary entitled to share of the deceased estate under Distribution Act decline his or her share in the property? How do we go about the procedure? Prisilla?
Sure. This question from Elaine is, can a beneficiary entitled to a share of the deceased estate under the Distribution Act decline his or her entitlement? Yes, the beneficiary can decline the entitlement. The beneficiary can enter into what we usually call a deed of family arrangement or settlement agreement to basically document his or her intention in declining this gift from the deceased. Upon executing this agreement, the administrator will have to apply for a distribution order to transfer the property to other beneficiaries according to the proportions agreed in the distribution, the settlement agreement, or deed of family arrangement.
Okay, thank you. All right, next one for Carmen. If the beneficiary under a will is a minor, but only one executor was appointed under the will it affect the application for a grant of probate?
Yeah, so based on the provision in the Wills Act, if there are beneficiaries that are minors, basically in the will you have to appoint 2 executors for the will. So it will affect the will and also will also affect indirectly the application for grant of probate.
Just to add on that point, in the event that there is minor beneficiary and there is only one executor, the executor can provide reasons to show the court that he or she is capable of administering the estate, despite the fact that there's a minor beneficiary. So with enough evidence to convince the court, the executor can actually administer the estate alone.
Okay, thank you. Next question from Lenny about grant of probate. If there are 3 executors in the will, is there a requirement to transfer all the assets to one executor prior to distributing the assets to the beneficiaries? Prisilla?
Thanks, Eric. Just to recap the question, is there a requirement to transfer all the assets to the first executor to distribute before giving it out to the beneficiaries? The short answer is executors act jointly, so there is no requirement to transfer to one executor first and before transferring the assets to beneficiary. How it is usually done is the assets will be transferred to all 3 executors before transferring to the beneficiaries.
Okay. From Sue, next question. Can a sibling who is not named as beneficiary in the parent's will contest the will of his parents? And what is the chance of winning the case? Yes, the most important question. What is the chance of winning?
The $1 million question, Carmen.
$1 million. Carmen, can you help Sue?
Yeah, okay. So as what I've mentioned earlier, yes, you can, anyone can contest the will. It's just that what are the grounds are you looking at and whether it's strong or not. So let's say you suspect there are reasonable suspicion that the will is forged or it was executed in undue influence circumstances, you can definitely contest the will, especially if you are a beneficiary or a child of intestator. So you can apply to do so, and chances of winning, if it will really depend on the grounds. If you have a strong proof, or like what I've mentioned, you bear the burden of proving it. So if you have strong proof of it, then the likelihood of winning the case will be quite high. Yeah. So it will really depend on the grounds that you rely on.
Yes, the more proof you give, the better chance of winning. Okay, next question from anonymous attendee. When there is no residuary clause in the will, does the executor for the will apply for letters of administration as executor with will annexed? If not, how should the executor proceed? Prisilla.
Yes, I believe that this will probably provided for some assets, but there are other assets subsequently acquired or discovered during the process of applying for a grant. I would suggest the applicant to apply for letters of administration with will annex in order to obtain the right to distribute the properties according to the terms of the will.
Okay. All right, we are down to the last 5 minutes. Speakers, we still have 26 questions. Looks like I didn't reduce at all. But let's go on. Power through to the next question. In applying LA, what if one of the beneficiaries cannot be found? So can the court grant LA to the applicant? And under what section the applicant needs to apply that to LA? Carmen.
Okay, so if one of the beneficiaries cannot be found in an application for an LA, technically we'll have to depend on who is the applicant. So if the applicant is also maybe the child, the administrator of the estate, then court may consider to just distribute the estate according to the Distribution Act, as what Prisilla mentioned earlier. So it will then fall back to the remaining beneficiaries under the Distribution Act, and the way of distribution will be according to that section, that particular section. Prisilla, do you have anything else to add?
In the event that the beneficiary can't be found, you can show the court what are the steps that you have taken to basically locate this beneficiary. If the court is satisfied that you have tried your best to do so, it will be depending on the court's discretion on whether to grant you the LA or not. Eric?
Okay. All right, next question by Eileen. Again, in furtherance of her previous question, can the children of the deceased agree among themselves on how to distribute the properties, notwithstanding provisions under the Distribution Act? Prisilla.
Yes, the short answer is yes. As I said just now, you will need to enter in a deed of family arrangement or a settlement agreement to document the intention. Yes, it can be done.
Okay. Next question. Can the executors apply order for sale to sell the property that is bequeathed to a minor?
So this will actually depend on terms in the will. So you would have to look back to what the wishes of the testator in terms of the property. They will usually request for like a person to hold on trust until the minor achieve certain age and then distribute the property. So you will have to fall back to what are the wishes and intention of the testator in the will. Yeah.
All right, thank you, Carmen. Next, can the executors use the money bequeathed to a minor to buy a property on behalf of a minor? Prisilla.
Right, Eric. Regarding this question, it will very much depends on the circumstances. Even if you want to purchase this property on behalf of the minor, it will depend on, like what Carmen said earlier, the terms of the will. If no such term is provided, then you have to apply to court to obtain directions. And you need to tell the court why do you want to purchase this property? Is it because the minor doesn't have a place to stay anymore, or what circumstances justify this purchase?
Okay. All right, we are down to the last minute until 4. I'm just wondering, speakers, how many questions would you like to answer?
How many more?
We have 23 more. So I don't know, maybe the last
10?
3 questions or 2 questions. Oh, 10. Wow. We have generous bunch of speakers today. All right. Then we'll go on with 10 questions then. Final 10. All right. Next question is for grant of probate. Is there a statutory time limit to apply for a grant of probate? Yes. Carmen.
So generally, there isn't any statutory time limit for a grant of probate or any grant of letters of administration. However, you have to take note if there's like a lapse of very, very long period, you will have to provide a very valid explanation to the court, as in, why are you applying it now? Yeah, so you will have to provide an explanation when you are applying for it.
Just to add on, generally is if it's beyond 3 years, then you need to provide an explanation in your affidavit to the court and explain the delay.
Right. Yes. So I think advice is probably do it as soon as possible. Okay. Next, any advice for one who is both an executor and a beneficiary of an estate? Prisilla.
I'm not very sure the scope of this question because it's rather wide.
Seems quite wide.
Advice? Yeah, any advice for one who is both an executor and a beneficiary? Apply for a grant of probate and get the property transferred to you as soon as possible.
Yeah, be careful, perhaps. Yeah, okay. Carmen, have anything to add on that? No? Okay. All right, then we'll move on to the next question. For Carmen, if the deceased, no surviving spouse and parents, have kids below 18 years old, what is going to happen to the deceased assets?
Okay, so this question has 2 answers. It will depend on whether the deceased has a will or without a will. So usually in the will, right, they will provide any caregiver or a trustee to hold the properties, or in event the child hasn't attained the age of 18, who should take charge to hold it on trust until the child has attained certain age. So it will depend on whether there's will or without. And where there's without will, usually a person who is in charge of taking care of the kids will then apply for, go to court to apply to represent them for a grant of LA. Yeah. So that's for me. And Prisilla, do you have anything to add on?
No, not for my end.
Okay. Next. Next question. The questioner is an executor, but the rentals of the property were paid directly to the beneficiaries. Is that against the law? Prisilla?
The short answer is no, it's not against the law if they are entitled to it. Yeah, that's my short answer.
Very good. Short and sweet. We'll move on to the next question. By Fung, if the will of the deceased has stated A is given half share of the house and B is given the remaining half share, but A has decided he does not want the said half share and want to give it to B, all right, can A direct the executor to transfer his share to B? Or A's half share of the property has to go to the residual clause? Carmen?
Okay, so for this, short answer is A cannot direct to transfer it to B because the property belongs to the deceased and it is his wish, just an intention to go to A and B. So if any event A doesn't want it, A cannot decide to just give it to B, but it will have to go under the residuary clause. Yeah.
All parties can enter into agreement to document intention to transfer the property to one another.
Okay. All right. Next question by Kelvin.
I think we answered a similar question.
All right. I think previously it was about financial institutions or something. Yeah.
Yeah.
Maybe just quickly answer this. What is the difference between us and Rock Wills? Is there any difference?
For me, I'll take this question. For me, I will always encourage our clients to basically find someone that you can trust in writing a will or representing you in any action. So is there any difference between us and Rockwill? For starters, we are a law firm and Rockwills is a will writing company. So I'm not sure what scope is provided by Rockwills under their will writing packages. It's best to check with them and make a decision yourself on this.
Okay. Next, can an executor also manage the compensation in insurance policy with named beneficiary as part of the estate? Carmen, I think I see you nodding there. What do you have an answer?
Yeah, generally, executor can manage the payouts by insurance company policy, but do bear in mind that usually insurance policies will have their own nominees under that. So you will have to follow the nominees under the insurance policies and to distribute accordingly to the beneficiaries. Yeah.
All right, thanks. All right, next one.
Is this the last question?
No, you have 3 more.
Okay.
Oh, your generosity.
Okay, thanks.
3 more. All right. Next one. Hi, I would like to ask if any of the beneficiaries refuse to proceed with the estate issue at the High Court or Amanah Raya, does the judge or officer can the judge or officer do anything for the sake of other beneficiaries? Prisilla, what do you think? Okay,
for this question, basically we need to determine whether this beneficiary who refuses to proceed with the application at the High Court is the executor. If the beneficiary is an executor, then you can actually file something what we call a citation against him or her to cite him to provide the will at the High Court and ask if he wants to apply for it. If he doesn't want to apply for it, then the other beneficiaries can step in. That's the short version of it.
Okay. All right. Okay, next we have Kristen who says thank you. Yes.
Does that count?
You're welcome. No, it does not count as a question, unfortunately, but you're welcome, Kristen. All right, we move on to, I think, the final. Let's give it final 2 questions. Right? Final 2 questions. One for each of you, all right? All right, for Carmen, if the deceased have no will and survived by parents and siblings, how is the distribution like?
Okay, so as mentioned by Prisilla earlier, if the deceased have no will, it will be an application for grant of letters of administration. So any interested parties, such as the parent or siblings, can apply for an application for the grant of LA, and the distribution will be as the table that Prisilla presented earlier. It will be to the parent and the siblings equally according to the Distribution Act as well. Yeah.
All right. At the finish line, we have the question for Prisilla. What should the executor do if he or she found out that there are 2 wills which have been made by the deceased, one in Malaysia and another one in that country? Both wills have covered assets at the respective countries.
Okay, for this question, if these 2 wills do not have overlap areas, you can actually apply for a grant of probate here in Malaysia for the assets here, and also a grant of probate in the other country where the deceased had assets at. If it's a Commonwealth country, you can apply to reseal the grant, but the Malaysian will doesn't contain any of the assets in the foreign country. Therefore, applying for 2 grant of probate will be easier that way.
Okay, very good. All right, with that, we end our Q&A session. I know there's still a lot of questions. Everyone is excited to get your views on this matter, but of course, unfortunately, we apologize, we cannot finish all the questions today. But if you have more questions, please do contact us, and we'll provide you with the details later. But before we end, I would like to make a few announcements. We still have a couple of talks coming up, lined up, and they will be as exciting as what we have today. We have one in the 6th of October, which is on the slides, which is by our Sarah Kambali and Marcus, regarding what can go wrong in a SPA for property. And another one on the 13th of October, which is about understanding shareholder agreements by our Cassandra and Tommy. And please do also sign up for more talks at this link in the slides. Secondly, do also follow us on our socials, Facebook, Twitter, Instagram, LinkedIn. The link is as seen in the slides. And if you would like to ask more questions to Carmen and Prisilla, do schedule a complimentary 30-minute video consultation with our lawyers, or by filling up the form in the link below, or you can scan the QR code, or you can talk to all our other lawyers as well. So thank you everyone for joining us today. It's been a very fruitful session, I hope. We hope you also found today's session informative and useful. And we'll see you at our next talk. Thank you everyone and stay safe.
Thank you everyone. Have a good day.